Obiokafo, latecomer. Professor here at Osgoode. I'm so sorry, I was teaching a class, so that's why I had to literally run from there to here. Thanks so much to my good friend Annie for holding the fort. And I think we should move directly to introduce a distinguished speaker for today, Professor Jean Allain, who's professor at Queen's University of Belfast. You're welcome, Jean. And
thank you.
Time is yours. I think he will speak. I don't know how long you want to take, but...
how long do I have?
40 minutes.
Yeah.
40 minutes.
Okay.
And
then question and answer. Yeah?
Yes.
Okay, great. Yeah. Thank you very much for the invitation. It's a pleasure to be here. I've known Annie for a couple of years now. We've done some work together, and so it's a pleasure to have this opportunity to speak to and also an engaged crowd. So thank you very much. What I'd like to speak about today is just this sense of slavery as a fundamental human right, agreed to as such here by the European Court of Human Rights as being a fundamental right, and yet it's a right that has up until recently rarely been tried in a court of law. And so I want to work through some of the dynamics as to why that transpires, and to work through with you so that you have a sense of why things have started to change. And the punchline, if you wish, was seen in that first slide, and it's about the definition. That in fact the definition of slavery has been something that has really stopped prosecutions up until recently. So I'll work through from an international perspective, and as I work through the international perspective, I think what's important to recognize is that when states are struggling to understand something, they often look to the international system for guidance. And if that international system is not giving the guidance, then they're a bit lost as to what they should be doing. So you have in 1926 a slavery convention, and in it you have a definition of slavery. And yet, during the League of Nations era, slavery itself is used in an instrumental manner to if you wish, attack, but to interfere with the only two independent African states at the time, Ethiopia and Liberia. And so in 1930, there's an International Commission of Inquiry into what starts off as being issues of slavery. But when the commission arrives, it's recognized that the definition of slavery doesn't apply. And it doesn't apply because the definition, I'll just remind you of what it says, is the status or condition of a person over whom any or all of the powers attaching to the right of ownership are exercised. Now that doesn't necessarily sound like slavery, and what you come away from it, I think, in first hearing it, is that it's about ownership. Right? And so at Liberia at the time, there wasn't chattel slavery, and so the commission started to focus on forced labor, and the end result was that the president and the vice president of Liberia had to resign, and it had to do with Firestone, the rubber companies, using forced labor, but in a sense, the state not doing anything. And so it was an attempt to deflect attention away from these tire companies, from these rubber companies, and place the burden on the state for having done very little with regards to individuals found in forced labor. And so it caused the resignation. So in an instrumental manner to attack the state. And the same with regards to Ethiopia. I've written a piece on Ethiopia and the League of Nations and looking at slavery. In it, the result is that Ethiopia, in the first instance, is there's an attempt in the early part of the 1920s to think about creating a mandate. So the League of Nations the League of Nations had taken the colonies of the losers of the First World War and transferred it to the winners with this notion of mandates. And then there was discussion about Ethiopia, which was independent, also becoming a mandate. And when that discussion started in the League of Nations, there was a push primarily by Haile Selassie to seek membership. And so, and the basis upon which an attempt was made to create this, what was a neo-colony, this mandate, was with regards to Ethiopia and slavery. Ethiopia is accepted into the League of Nations, and then later, when the Italians seek to annex Ethiopia, they use as one of their pretexts the notion that Ethiopia is not civilized. The notion of civilization is used from about 1880 to around the 1920s as very much an element of international law in which states are allowed to be brought into the nations, the so-called civilized nations. But it's a moving target in which ultimately it's the European states, it's the states that are part of the League of Nations that decide what civilization means. On that basis, the Italians sought to justify the annexation of Ethiopia also on the basis of a failure to suppress slavery. So in that context, during the League of Nations context, you have a real sense that slavery and this convention is utilized as a target against the other, against those that aren't part of the League necessarily, but against African states in the end. In 1956, you have a supplementary convention. And that convention is right at the, well, you have the start of the non-aligned movement and the Badung Conference. You have this movement towards independence. So the start of the decolonization process is taking place, but it hasn't really started with regards to the United Nations. There's a logjam between East and West, and as a result, there hasn't been much movement between the original members of the League of the United Nations and so about 52 states, until you have today about 193 members. So you have a tripling of states. But it doesn't really, that logjam doesn't really break until 1960, 1966. Well, no, not, so yeah, 1950s is when you start this movement. In that context, the 1956 convention is, like the 1929 convention, 26 convention, the slavery convention, and the supplementary convention, they are colonial instruments. Right? And as originally conceived, the 1956 convention was meant to be a convention for the abolition of slavery and servitude. But instead, this notion emerges, and it's a bit technical, but in broad strokes, what happened was that the 1956 convention wasn't about abolishing slavery. It was about getting rid of it as quickly as possible was the language, right? As soon as possible. In 1956, despite the fact that the 1948 Universal Declaration said that you should abolish slavery and servitude, in 1956 they weren't willing to move to abolish slavery, yes, but not servitude. So with this kind of elephant in the room of the Universal Declaration, states said, well, we don't want to abolish servitude right away. We want it to be progressively and as soon as possible. And so what the diplomats did was, well, let's just redefine and let's not call it servitude. Let's call it something else. Institutions and practices similar to slavery. So if you look at the legislative history, and I'll talk a bit about legislative histories, but if you look at the legislative history, the drafts of this convention are abolition of slavery and servitude until the last draft, when it changes with this language of institutions and practices similar to slavery. In 1966, when there is enough momentum has been created by the decolonization process that southern states, newly independent states, are now the majority in the United Nations, it means that they control the agenda of the democratic bodies. So they control the agenda of all bodies but for the Security Council. In that context, they start to push in the 1960s and throughout the 70s and 80s. Apartheid is the big issue within the UN, primarily because during the Cold War, East and West cannot agree. Dag Hammarskjöld pulls for this third group, the non-aligned movement, and pushes to have their agenda brought to the surface, and that agenda is about apartheid and decolonization and colonialism. There's an attempt to bring apartheid and colonialism into the 56 Convention as another type of slavery or servitude. So, apartheid as slavery, colonialism as slavery. There's a realization during the discussions of in 1966 in the ECOSOC, in the one of the main organs of the United Nations. There's a realization that while newly independent states have 50+1, the majority, they don't have 66% of the votes, which they would need to carry an international treaty. So in deliberations over international treaties, you need a 2/3 majority. They don't, so they're in this gap between plus 50 but under 66. So they can monopolize, if you wish, the agendas of the political bodies, but they can't change international law. As a result, they equate apartheid and colonialism not to slavery or to institutions or practices similar to slavery, but they create this term of art, a practice similar, sorry, this is, see, I've even got it wrong. It is a slavery-like practice, to demonstrate the confusion. Slavery-like practice. As a result, there is confusion. Right? Because we no longer know if we're talking about the law or this term of art. And, as I've just made the mistake myself, it is seen as being interchangeable, right? And so, by the time we get to 1966 and beyond, throughout the 20th century, as law related to slavery, there is a sense that there is, that we don't really know what we're talking about when we're talking about slavery. The main groups that are interested in slavery at the time, Slavery International, they have, in a sense, abandoned the legal definition very early because, having abolished slavery, they wanted to expand it to deal with forced labor, to deal with other types of exploitation. So, throughout the 20th century, there's very little legal cases because of this background. Because, first of all, it's seen as being an instrument of the West, and second, because there is this confusion over what are we talking about when we talk about slavery, of servitude, etc. Now, in the 21st century, very early on, 2002, 2005, you have two international cases which come to fundamentally different understandings of what that definition means. In the first instance, in the Kunrich case, the Yugoslav tribunal says, in essence, that it's not about legal ownership. It's about, and it uses the language, it's about something more than that. It's about the powers attaching to the right of ownership. And I'll unpack that for you in a moment. But the European Court in Seleade says that it's about chattel slavery. So at the international level, you're getting mixed signals, right? So the European Court says, look, in the case in this case, which dealt with a young woman who was a domestic, had been working domestically and was for all intents and purposes enslaved. But the European Court said, we have this lesser type of exploitation, servitude, and we'll say that this is servitude. We will reserve slavery for a context in which someone is legally owned, right? In the context of Europe, in which, well, in the context internationally, where there's no country that allows for the legal ownership of an individual. That said, Europe had lived through the National Socialists during the 1930s and their slave labor, their forced labor, in which it had been reintroduced into law. And so there's some context there for saying that maybe the European Court was saying, well, we'll hold on to this. since then, they've moved on to an understanding that slavery today can exist in a de facto situation. In the Queen versus Tang, it's a case of what is, in essence, the Supreme Court of Australia, the High Court of Australia, in 2008, where it seeks to unpack the 1926 definition and to say it is applicable. And I think it does a very good job in the sense that it picks up on the definition, it unpacks it, and it reads through an understanding which then I've worked on. I must say, I had influence in Tang because the court there cites me, and there's I'm involved in an amicus beforehand, so it picks up on my arguments to develop this understanding of slavery in a contemporary context, of using this definition in a contemporary context. And how is this done? Well, in international law, you have this kind of witch's brew in interpreting. You have 4 ingredients, and it's for judges, it's for legal advisors, it's for anyone in trying to interpret international law, that you use the basis of interpretation from the Vienna Convention on Law of Treaties, Article 31, which talks about acting in good faith when you interpret, right? The ordinary meaning in its context, and a look to the light and the object, in light of the object and the purpose of the treaty, right? So those are the 4 ingredients that you take in interpreting a treaty. Now, as a supplementary means, you can turn to the so-called travaux préparatoires, the legislative history. And in it, you can, so if an interpretation of that kind of witch's brew leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable, then you can turn to the travaux préparatoires, the legislative history. And so this is what I've done. I went to Geneva, to the archives of the League of Nations and to the Library of the United Nations, and produced a book in 2008, precisely that. I go article by article of the 1926 Convention and on the 1956 Convention, and read through what the states were thinking about and how they were seeking to understand the definition. So what I was trying to do is to help states understand, to help us understand what that definition means today, so that we could have what is recognized as a fundamental human right, that it could be dealt with in a legal context where the anti-slavery movement throughout the 20th century did not use law as part of its arsenal. It didn't have a legal basis for dealing in issues of anti-slavery. So there's the definition once more. And so I'd like to break it down for you. And so, yeah, so if you look at that definition, if we were simply talking about legal ownership, then I've reformulated it in a way that this is all you would have to have legislated if we were talking about chattel slavery of old. Slavery is a person over whom any or all of the rights of ownership are exercised. But the definition doesn't read that way. The first element of it is it talks about status or condition, right? In the context, and so I go back to the travaux préparatoires. In it, it's clear that when they're talking about status, they're talking about legal status. And remember, it's a colonial document, 1926. When they're talking about condition, they're talking about custom, right? But they're also talking about it in the sense, well, and so here's what Tang has to say. So the High Court in Australia. Status is a legal concept. Since the legal status of slavery did not exist in many parts of the world, and since it was intended that it would cease to exist everywhere, its evident purpose of the reference to condition was to cover slavery de facto as well as de jure. So in that context, when we talk about the condition of slavery, we're talking a sense of a person being not owned, but tantamount to ownership, right, in a de facto situation. So someone who is not legally owned, but is in the condition of slavery. Okay, so that's the first element of it. So I've introduced one element of the definition, reintroduced it. Now, if we go beyond that, that it's not about a right of ownership. It's about exercising the powers of the right of ownership, right? So it's one step removed from exercising ownership, right? You are exercising, it's not about ownership, it's about exercising powers attaching to the right of ownership. And there, what I like to think about in that context is if you think about drugs, for instance. So Annie and I have a dispute over a kilo of heroin, right? So what do? We go to a court of law, right? You have a dispute over ownership.
Friends, you know.
It's the only thing that sustains our relationship, really, yeah? So we have this dispute. What do? We bring it to a court of law, right? If you have a dispute over something, you bring it to a court of law, right? Of course, you wouldn't in this context, right? Because the judge is going to look, and what's the judge going to say? He's not going to decide who owns it. He's going to ask, well, who controlled it, right? And then you're charged for possessing illegal drugs. Well, think of it in the context of slavery, right? You can't own another person, right? In the same context, if you think about torture, the fact that you've outlawed torture doesn't mean that torture doesn't exist, right? The fact that you've outlawed, in a legal sense, slavery doesn't mean that slavery doesn't exist. And if you do that parallel with illegal drugs, then you don't ask who owns it. You ask who possesses it, who controls it. Right? So now we're starting to realize that this definition actually has some resonance because this is the lived experience of a person who is enslaved today. It's about controlling that person, right? Tantamount to possessing them, or tantamount to ownership. And how does that happen? Well, it's about controlling somebody as if you possess them. It's about possession, right? So what we're trying to do in understanding this definition is to unpack it, but also to have it legally, internally consistent with the definition, right? So if the definition is built on this property paradigm, then we unpack it within the property paradigm, and much to our surprise, it works. So after Tang, so I'm involved in Tang, and Tang picks up my reading of the definition, and then it makes a determination that yes, there were powers being exercised, that there was control over these 5 Thai women. They were sold, right? And then they were controlled in such a manner that they couldn't leave, and they were used. They were, their money was limited. They were paid a limited amount, etc. But on that basis, the court went as far as it could in that case. It didn't go any further. And so what I sought to do was to get a group of people together, academics, practitioners, historians, property lawyers, and try to unpack what does it mean to exercise the powers attaching to the right of ownership in the context of contemporary slavery. In other words, what does it mean in a de facto situation to own somebody, using that property paradigm? What we found in the first instance is that, and we refer in the main to a kind of a piece that is now entered the canon of common law, and that's a piece by Tony Honoré on the instances of ownership. And what he says is that ownership, the substructure of ownership, is possession. Everything else flows from possession. So, and possession is about control. Once you control, then you can do different things. Once you have possession over something, you can use it, you can profit from it, you can destroy it. Right? This is typical property law reading of an instance. And so we introduce, so we go through and meet in Bellagio, and what I've often said about Bellagio is it's been described as kind of summer school for royalty. It's where academics go, when academics die, it's where they go to heaven. It's kind of a place which is very, they lay things out for you, and it's very easy, and it's very nice, and it's a beautiful setting, and you're treated great, and there's champagne flowing all the time. It's quite the place. But my point is, if you ever want to settle anything, that's the place to send people, right? If you want to settle the Middle East, send them there because they'll agree to anything. Right? Now I'm being a bit facetious because for 80 odd years, right, this definition was deemed not to apply. And yet when you got the historians in, when you got the property lawyers in, when you got the people dealing, the practitioners in contemporary slavery, there was agreement. Yes, this captures the essence of what it means today. Historically it works because historically not all people that were deemed to be slaves were in fact legally slaves, right? But it was about control. And so we developed in the first instance a number of guidelines, and this guideline, so in the case of slavery, powers attached to the ownership should be understood as constituting control over a person in such a way as to significantly deprive that person of his or her individual liberty. So it's about loss of agency, right? It's about a person who no longer has control over their life, over the decisions that are important to them, with the intent to exploit through the use, management, profit, transfer, or disposal. Those are the instances that Honoré talks about, more or less, in the context of ownership. Usually the exercise is supported by and obtained through the means such as violent force, deception, or coercion. Now, they come out in 2002. Since then, we've had a couple of successes in the sense that, and this, sorry, 2012, had a number of successes, and it comes, I think for me, the lesson about this is about academics engaging with practitioners, because it was the practitioners who saw it and who brought it forward. So in the context, in 2013, there is the Global Slavery Index, which seeks to determine the prevalence of slavery in 162 countries. It uses as its basis this guideline 2. Excuse me. The other success is that I was asked to give evidence before a joint committee of the House of Lords and the House of Commons in the UK over their currently going through a modern slavery bill. It's very early days, but their first draft uses the essence of this as their definition. And I was just telling Annie that I was pushing for the 26th definition, right? And one of the lords, the ladies, said, why are you stuck on this 1926 definition? You have these guidelines, and that is what slavery is. Why don't you talk about it in the context of contemporary slavery? Let's drop this ownership stuff. Let's just talk about it so that the police, the prosecutors, the people working know what slavery is today. It's about controlling somebody. And once you control them, you can do these things. Right? And so there's movement in the guidelines, in bringing the guidelines to life, and also that we're starting to see prosecutions as a result, because you can now put your finger on and try to identify. And for me, the objective was always about putting parameters around slavery, right? Because the United Nations itself had gone so far as to talk about incest and about child or youth incarceration as being slavery, right? And we have the examples of apartheid as slavery, despite the fact that there had been an apartheid convention where slavery is not mentioned at all. The point is that slavery has a visceral element to it, and it's bound by, in a friend of ours, in the language of Joel Quirk, rhetorical inflation, that it's used oftentimes, right, to attach itself to a social ill, to give it that momentum that one feels when they talk about issues of slavery. So for me, what I sought to do in establishing a functional definition of slavery was to draw parameters around it in which we could say, you bring it to court and you know what is slavery and what isn't. Right? Now the guidelines were the first step. They were conceived as a kind of a conversation between us and the judges that would decide, and the juries that would decide, and the prosecutors. Because we weren't saying this is slavery and this isn't. It was about, you take this on and you decide where the line is. You decide where the parameters are, but we'll give you those parameters in which to work in. So now let's unpack it a bit more. and turn to this notion of buying, selling, and transferring. So here is a case of a rather famous footballer who was, in the words of his manager, his coach, was sold. Right? So the headlines read, "My decision to sell Mario." Right? Now, would we say that this is a case of slavery? Right? The person was sold. No. So buying, selling, or otherwise transferring a person may provide evidence of slavery. What's needed is having established control tantamount to possession. The act of buying, selling, or transferring of that person will be an act of slavery. Right? So first of all, right, so in this context, in fact, he's not being sold, right? His labor is being sold. Commoditized, but being sold. For me, the big question, and I think I often hear it when we're talking about contemporary slavery, can the person walk away? Right? And so professional athletes, we have it in the context of North America, where professional athletes to being traded will say no and they'll sit out a year or something like that they don't have to, right? And so in that context, right, so we're looking for two elements. Fundamentally, it's about control tantamount to possession, right? So once, we would not ordinarily allow ourselves to be sold, right? So what is it that allows an individual to be sold? It's about control. And that control is typically, and so in a sense my discussion thus far is rather benign, but it's about violence, right? It's about using violence against somebody so that they can't say no, right? You control them, right? And so people would not willingly allow themselves to be used, to be bought or sold, to be exhausted in the context of being used up, unless there is this element of control, and that control manifests itself through psychological coercion, typically through violence, which then turns into psychological coercion. The threat of violence is enough to control afterwards, right? So then we get closer to this sense of what slavery means, right? And so in that context of a contemporary setting, what we seek to identify then is there control? Right. So it's different, for instance, from forced labor, because forced labor manifests itself within an employee-employer relationship. But that relationship is an 8-hour or 12-hour, etc., but then the person walks away. Right? Slavery is about more than that. Right? It is about controlling, decide if and when you eat, when you sleep. You know, it's that control that you have. Blackstone's definition of ownership is despotic control, right? Complete control, right? And so what this means is that when we talk about slavery, we are creating these parameters around it, which allow us to make the distinction between slavery and lesser servitudes, including forced labor. I think for me the big thing too is that we get away from looking at the form of something, right? And so throughout the 20th century, it was child marriage is, child soldiers are. But then it went on to look at these other things, right? Trafficking is slavery. What we do is we say, no, it's not about the form, it's not about what you call it. It's about the substance, right? You have to. And so early marriage, child marriage may be slavery, but you can't make this overarching argument. What you have to do, and the law is well placed, of course, right? To look at individual cases and ask in those individual cases, right, about marriage consent, right? Is that consent freely given, right? And oftentimes with marriage, what we're talking about really is about consent at the time of the wedding, right? The question is about later. Is that consent still freely given, or is control established? So that, for me, is you've seen why it hasn't been tried of late. Confusion around the definition itself. It was used instrumentally. And now, with this, I think we're in clearly a neo-abolitionist era in which people are interested around the issues of exploitation, of trafficking, and of contemporary modern slavery. And in that context, I think what we've sought to do, and it looks like we've managed to do it, and that is to give this anti-slavery movement a fundamental tool, and that is the law as a means of trying individuals for contemporary forms of slavery. Thank you.
I know you all join me in thanking Professor Allain for that very stimulating, clear, shall I dare say, with a lawyer's clarity. I know I'll be opposed by many in the room. I think we'll have time, quite a bit of time for questions, so just indicate if you want to jump in. Yeah? You want to? Okay. Okay.
Here, I'll take the mic.
Okay.
There's two here.
There's two, okay.
Okay. Okay. Oh, you have it right.
It's just for the recording.
There's one right there.
It
yeah.
doesn't amplify your voice, just the recording.
Okay, so I'm going to tell you a little bit of the context why I made this question. So I was working as a lawyer for an organization who took a case against Nidera for slavery cases in Argentina. And that was my first PhD project. And then I changed it to work with sex workers. So in a sense, the whole thing about all these discourses about trafficking and slavery just, was crossing both topics in a big time. So what I wanted to ask you was mainly about this border between control and will, and the way certain discourses just try to say, in the case of sex workers, abolitionists sustain that nobody, no woman, and only they talk about women, so no woman will ever accept to be a prostitute. So it's always, slavery. It's always what they say as trafficking in women, etc. And then there was this case in Argentina in 2004, before the law was changed, and we had a law against new forms of slavery. That said, the judge said that there was. So the case was that there was this group of Bolivian workers. So they were working in this textile factory, and then they realized that they couldn't really go anywhere, and they were working long hours and in very bad conditions, etc. And what the judge said was, well, they kind of inherited this custom from their indigenous community, so they were not actually enslaved. They actually kind of like what they do there. That was very, of course, very in the time, was very contested, etc. And that raised a lot of other legal regulations and stuff. But the point there was, so how can you read that point between consent and control, will and control, and what part are you going to look at what the person in the concrete case, what is it saying? If the victim is going to say she's such or not, does that count or not? So just, okay, I hope I've been clear.
Yeah, thank you very much. Yeah, I mean, for me, part of it is that the legal process then can help in the sense of saying, well, we're not going to make these broad claims, right? That prostitution is slavery, for instance, right? What we're going to ask is in those instances, right? But we oftentimes, with prostitutes, is that there is this kind of sex workers with this kind of internalization, right? A kind of Stockholm syndrome in the sense of internalizing because there's not necessarily alternative. And I accept that there are some sex workers that go into it willingly, etc. And so, but for me, the issue then is to also ask not only about the witness, right, and her testimony, his testimony, her testimony, but also the peripheral elements of it, right? And that's in a sense where in cases such as these, it's about asking other questions around it, right? Where were you living, right? Did you have access? Could you leave? Could you, and also try to understand. So what about, you're dealing in an illegal context often, even if you're not. What about remuneration? Who's getting the money? So there are these kind of ancillary questions that you have to ask around in the context that you recognize that the witness is vulnerable and oftentimes dependent on, right? And I think, for instance, with regards to spousal abuse, the same kind of questions come around. Is there are vulnerabilities there that the legal system has to engage with, and oftentimes in the gender context it fails to do it, right? And so for me the issue around is trying to establish control. Establishing if there is in fact control tantamount to possession is not only asking the witness, but looking to these ancillary elements of that person's life, and to what extent do we accept that person had a choice.
I think I saw a hand there before. Come to you, Sas. Do you still want?
My question was,
can you just pass the mic to him?
You were talking about chattel and slavery.
Chattel.
And servitude. Where does indentureship fall into it? When you mentioned the second definition of slavery, does it fall in more with the first, or does it also apply into the second?
So if you're talking about the 26 versus the guidelines,
yes.
But in both, so chattel slavery is what would have been. Chattel is movable property, right? It is owning something, right? So that's indentured. So indentured typically is about where you sign a contract, right? So it's debt bondage, right? So you accept. So it's very common in the Indian subcontinent, where someone who is very poor, who has very little access to money, where something happens. Not unusual is with regards to an accident of some types, and so an emergency is medical attention is needed, or for instance with regards to marrying to let's say the obligation of the family to marry off a daughter, right? And so they raise money for a wedding, for etc. In that context, the indentureship, the only thing that they have as collateral is their work, and so they offer their work in exchange for this money. And when it becomes exploitative is when the amount of interest that is being charged and the work conditions are such that it's impossible, right? And so so what transpires in a case, and I must say that the 1956 convention as a type of servitude, indentured or debt bondage is one of those. There are 4 servitudes in the 1956 convention: debt bondage, serfdom, servile marriage, and child trafficking. Yeah, so in the context of this servitude, there is control that's established, and on that basis, so the control is created not by violence, right? It's controlled by debt, right? Now, I can get into the technicalities of it because the way that definition, the 1956 convention says that these servitudes, these 4 servitudes, can also be slavery, right? And in fact, the way you read those, my argument has been, is if you actually read those definitions the way they've been outlined for debt bondage, it's the only one that's really a servitude. So it doesn't require you to have complete control over a person, but whereas servile marriage, it's about transferring, it's about buying a bride, it's about inheriting a widow, right? And so if we talk about buying, about inheriting, then you hear the kind of property element in which the wife is treated in this context.
Thank you for that talk. My question is, I guess, fairly similar to the first question, in the boundary, the boundary between free will, and the lack of free will. And you were talking, in answer to this, either the first or the second question, talking about, well, we look at outside circumstances, not just the person's own views. How would that for example, apply to, let's say, an arranged marriage of a young child, for example. My grandma got married at 9. I don't think she would have said that she had a choice about it. And I don't think she realized that she had a choice or couldn't have a choice about it. It was just something that culture imposed upon her, society imposed upon her, its family expectations. There's pressure on the families on both sides.
Absolutely.
I mean, how do you take that into account? And do you simply, can you go into a culture and say, look, you don't think it's servitude, you don't think it's slavery, but we coming in from outside at that point are going to say, well, that is. And how do you draw that? How do you negotiate that? I've got a lot of problems like this. 4 or 5 different voices going off in my head arguing against each other. I don't know how to draw the line.
Yeah. I mean, and Annie and I, that's the link between us is about marriage, about forced marriage. And for me, I have problems in the sense that I've, so in fact, you may not recognize that that marriage in international law, the first time marriage is dealt with in international law is actually the 1926 convention. It's about ensuring that marriage is not slavery. And it does it by saying that there has to be consent and that there has to be an established age. And that's recognized today as, is recognized as holding, right? As most states will have legislation that says you have to consent. But again, it's not about consent in marriage per se, it's about consenting on the wedding day. Right? In the context that you've just talked about, in which there's pressure on the families, it's an arranged marriage, etc. Right? So how do you determine free will in that context? Very difficult, right? And of course, with regards to age, right? So we allow that one can only give free consent at a certain age, and yet with marriage, maybe there's a willingness to drop that. So I must also say that I tend to deal with it at a sense of abstraction, and my easy way out is always to say, well, let the courts decide, right? I'm just kind of giving these guidelines. It's up to you to work it out. And in part, it's because of these kind of fundamental problems that we have to struggle with within the different societies in which the law is being applied, right? It's an easy way out for me, right? But it's about, these struggles that you're having, as you say, in your own mind, are also the struggles that we have to, in various societies, struggle with, right? And to say, but you're right in saying, can a 9-year-old actually consent? Is it free consent in the ways that we would accept it today, right? And is that something that we want to allow on a person, right? And so that's where I think we have to think about it. Now, the other part of it, and it's a question that I've asked before, is, are you willing to stigmatize? Is it a stigmatization? I think it probably is, to say that's slavery, right? And so maybe there is maybe that's not the language we should be using in that context. Then again, it might be in societies where we say, we've established that this is not acceptable. We've accepted that it hasn't been acceptable for a very long time, that maybe we want to say, well, this is what's happening, that this is a case of enslavement. Now, for me, there's 2 parts of it. One is that, from a legal perspective, right, would a jury be willing to accept that, right? Simply because the language, right, that it's maybe because of this kind of rhetorical inflation that you get from it, maybe that's too much, that juries would say, no, it's wrong, but we don't accept that this is slavery. Right? So that's the first part of it. The other part is, how do you work out, how do you try to deal in a relation, I guess the context for me is always asking the question about the point of view of the person who finds himself in that situation, right? Because they are in, first of all, they're young. So let's say the context is someone who's even 16, right? You have this, your parents, your family, right? Everyone around you is saying, do it, right? There are large stakes in this marriage, right? And so for me, this is also part of it, is that, and also oftentimes money is exchanged, right? In that context, these are all things that inevitably create coercion. And that coercion then creates this kind of control where this young person cannot say no, right? And so from the state perspective, they've said yes, right? And so the 1926 Convention actually does three things. It says an age, right? It says consent, and it says in front of an official body, in front of a state representative, right? And so the state is there because of the fear of enslavement in the context of 1926. So originally conceived, all these protections that we have today, the reason you have, you sign a registry of the state of a marriage and that you freely consent, right, is because in the 1920s there was a fear of exactly what you've been talking about, right? But again, it's in the context where this law is focused on the other, right? It's about change. This doesn't happen within the states of the League of Nations. It happens out there, right, in a colonial setting. So it is an attempt to deal with these practices, right? But in the context that we would see it today would be, for instance, in the Banjul Charter, the African Charter, it's about traditional harmful practices, right? Would fall into that kind of context. But yeah, so again, I don't have the answers. I think I've got a path, but for me, it's about the law finding its own path in the various societies. Do you just want to follow up?
Just a quick follow-up.
Sorry.
Sorry. Do you think that might be easier to, rather than approach it from the point of the control being exercised on the person, looking at the person as, is there autonomy? Rather than, because that might be an easier and more palatable thing to
well,
guide across.
if you think about that definition, right? Well, in that kind of Bellagio definition, right? It's about the loss of liberty, and for me, I talked about agency, but it's also about autonomy, right? Because you have that inability, right? And so I'm thinking about it more, I guess, maybe from let's say maybe our differences, there is no difference other than it's the same, it's two sides of the same coin. You're looking at it, let's say, from a human rights perspective, from the victim's perspective. I'm looking at it from a criminal perspective of the perpetrator, right? Does the perpetrator exercise control, right? Whereas you're coming from the other perspective, right? Which is loss of autonomy, loss of agency, loss of liberty. We're getting at the, it's the same thing, but it's just two different perspectives.
Thank you.
So Nathan, after you.
Well, thank you for the talk. I thought it was very good. And my question, it's not really a question as much as if you could comment on this, and it's kind of a follow-up to the first two. But kind of shifting the form to global labor standards. And I think particularly, I just want to know if you could comment on, in the context of race to the bottom economic development and neoliberal global economics. I think it's particularly interesting with talking about free will, but what about economic coercion? And I thought it was interesting when you said that forced labor allows the person to walk away. The first thing I thought was, well, walk away to what? And how are they walking away? So yeah, I don't really have a question, but if you could just comment on that. Thank you.
Yeah, I think, first of all, the ILO's standards of decent work are, to my thinking, not very decent, in the sense that they set, for instance, so there's a convention on minimum wage, and so the ILO doesn't set a minimum wage. What it says is every country has to set their minimum wage and then has to follow up to ensure that it's respected, right? And so that gets us to a context where the minimum wage in Bhutan is 60 times less than it is in Australia, right? So there's clearly an injustice there, and it doesn't compute. The second is that there is much discussion around today, and so tomorrow I'm at the International Studies Association talking about issues of forced labor in the context where my colleagues, I think, I think for me it'll be very enriching, because it seems to me that a lot of the discussion around slavery is a bit of a nuclear option that states, and especially where I live in the UK, in that context, the government is prepared to go after cases of slavery, but is unwilling to enforce the minimum wage, is unwilling to enforce labor standards. And so what they're doing is creating this nuclear option, right? If you misbehave to the extent that you enslave people, then we will go after you, right? But we will not do anything less than that. So you work to, your race to the bottom within the UK is go this far, but not any further, right? And so it's all this discussion around slavery when at the same time they're dropping their standards, they're not enforcing ILO standards there. And so from that perspective, I think for me one of the interesting things is to try, so I'm giving you this context of the slavery. I think tomorrow I'm going to hear it from my colleagues on the other, and I expect and I hope so, because I think there's a discussion that has to take place there, is whether this neo-abolitionist move is an attempt not to react to, and I think what the reason this neo-abolitionism comes about is, on the one hand, that you have these vestiges, kind of colonial type vestiges of slavery, but you have this new slavery, which is a result of globalization, right? And it's about immigration, right? So I've just done a study of forced labor and looking at the kind of way in which companies make money from, or people make money from forced labor in the UK. And there it's clear that the vulnerabilities are sometimes inherent in the person, and so people are forced into labor where they are dependent on drugs, where they are down and out, etc. But the bigger pool are people who are legally in the UK, but aren't allowed to work in the UK, as well as those immigrants that find themselves in the UK and can't work. And so the state is creating this pool of people who are vulnerable to exploitation, right? In that context, the UK is saying, it's saying, we will create this pool, right? But don't go as far as to enslave these people, right? And so there's this area, right, where the state has abandoned people in a globalized context through immigration laws and creating mass vulnerabilities, the vulnerability of this context. So I think abolition, this neo-abolitionist, is an attempt in the first instance to deal with this pool of people that, because of globalization, because of the ability to move, are vulnerable. And it seems to me that maybe we're heading towards a context where the states say, yes, we understand that, but let's fight slavery, right? In the context of the nuclear option versus actually addressing these kind of global inequalities.
Quick one. Thanks for that, Professor. Quick question about the Bellagio guidelines definitions you've been working on. I'm just curious if you've encountered any pushback on that definition, and what are some of the responses you've had to those? Because I'm thinking that it seems fairly, proper, very generic, covers a lot, but I'm just wondering, were you surprised at all about maybe some of the responses you got or the criticisms? Thanks.
Yeah. I must say I haven't heard much criticism around it, but I do know that there's a couple of academic works that are around, that are in the pipeline, so I'm looking forward to that. But part of it is that, if you wish, we captured the practitioners that are also the kind of the leaders in the anti-slavery movement, and so they have been quite vocal in their support. But also we're seeing that the states are interested in it as well. Right? For me, where we've heard, where actually, and it's not a critique actually, but where we've heard a challenge is to say, we don't like this in the legal context, but it's a very good tool for telling people what contemporary slavery is all about. Right? Now, for me, that part of it actually is for me the added value of this, because I didn't go in trying to establish a definition of what modern slavery is today. It wasn't my goal at all. It was about the legal context, right? But much to my surprise and the surprise of people around us is that I think we've captured the essence of what it means to be enslaved in a contemporary context. So where we've heard critiques is to say, oh, forget about the law part, that might not hold. But it's a very good tool for telling us what it means today in the context where, for instance, so one of these trend leaders is a guy named Kevin Bales, who's very much front and center, has done some very, very good work. And he, for a very long time, he was always susceptible to someone saying, what do you mean by slavery? right? That's your interpretation. But what about my interpretation, right? By basing it, by giving it this kind of law's empire, right? This ability of the law to, and the fact that the states have, in 1926, they opened up the definition again in 1956 to renegotiate and found it acceptable. In 1998, for the Rome Statute, again they opened it up to discussion, and it was found to hold, right? So there is this legitimacy attached to that definition, right? And on that basis, then, if you can build your arguments around what is the established definition of slavery, then you're in a better place than saying, this is what I think slavery is, right? But we've managed, I think, to do both. And that is to use the legal definition, but to give it an interpretation which is internally consistent with its property paradigm, but also captures the essence of what it means today. So that was the unintended consequence, or it was maybe my lack of foresight, but that's not what my original goal had been. And so this thing has done much more than I had expected, because it seems that we're in that it's going to take hold. Now, I was at a conference some years ago in which one of the main panelists, it was about the international system and constitutionality, in which one of the speakers said, I wrote this piece, and typical for international law, I heard nothing for 4 or 5 years. And then all of a sudden, I was being invited to panels. So it takes time for these things, right? And so I think for me, I'm anxious to see critiques. I want to see, to what extent it holds up to scrutiny. But it seems in the first instance that there haven't been critiques really that have challenged the fundamental basis of it. And I think part of it is because it is internally consistent with that property paradigm.
Is there still time? Yes. Okay. So thanks very much for a very rich presentation. I was similar to the second last question. Throughout much of the presentation, I was trying to think, well, how are we going to distinguish this slavery you're speaking about from, let's call it wage slavery? There was a kind of polemical term going back to the 19th century, that kind of anti-capitalist notion of wage slavery, economic coercion, creates the same conditions for workers as did more formal slavery. And I really thought at a certain point I came to understand the distinction in the definitions came at the point of physical coercion. So for example, you mentioned slavery being control tantamount to possession. And I thought, well, that still doesn't quite get there for me, because you can have economic relations with a person. You can have information over them and blackmail them and own them in that way. But it really came down to physical coercion. So then I was struck that there were these subcategories where it goes, debt servility is not, is not physical coercion. So I thought that's really it must get very challenging at that point to do what I think the definition is trying to do on behalf of the legal technology, which is to make the law workable. That is to allow for the law to be implemented, for prosecutions to take place without having to prosecute, everyone. And so I was sort of just very, I wonder if really it's about the limits where we say, okay, there's something really egregious that we're going to separate out and treat distinctively and give the nuclear option to outside of market relations that at times can be horrifically exploitive and abusive. Just as a little side story, a friend of mine works for an IT company, and he was telling me recently about how they have a new contract with a Taiwanese company to have their phones manufactured at what they call a campus in China, where there are 120,000 workers and they have 12-hour shifts, and 60,000 go in and 60,000 go out, and the suicide rates are through the roof. And I jokingly said to him, well, have you visited your slave plantation yet? Really meaning to capture a state of affairs that is something about the conditions of work. And so really, I just found at the end of the day, maybe the definition can never answer that question other than in an instrumental way, which is to say, well, we can't do everything, so we'll try to isolate something really horrific. Focused primarily, I guess, on the physical coercion and the brutality. Is that a fair comment?
Yeah, well, so I published a book in 2013 called Slavery and International Law, but it's subtitled, I think, of human exploitation and trafficking. But actually the book is only 1 or 2 chapters on slavery, but it's also looking at these lesser servitudes, right? And to make these distinctions, right, of slavery, but then of servitudes, of forced labor, right? These different types of exploitation. And my understanding of exploitation, and it's a big polemic, what does exploitation mean? My approach is to say exploitation is when A takes unfair advantage of B, right? And what is unfair? For me, it's the law will decide, right? So if you are acting legally, right, then you're not exploiting someone, right? So that's from the legal perspective, but it doesn't take in all this notion, right, of market forces and actually truly exploiting someone, right? So in China, that may be completely legal what's taking place. It meets ILO standards, et cetera, right? But we would sit here and we would say that's exploitation, right? I gave a talk some time ago, and where someone said, you know, Marx says, you know, everything is slavery, wage slavery, right? And okay, that's fine, but that's not where I'm coming from, right? Where I'm coming from is to say, let's give this some type of legal hold where previously there was none. And so I don't really address this kind of, let's say, slavery in a globalized context, right? And so I don't know where that gets us, other than is, and even at the notion of what forced labor constitutes, right? I think there is still, so I think my definition of allowing the law to decide what is exploitation, it works from a legal perspective, but in reality, there's much more exploitation that we would put above that bar, right? That we would accept that the laws in places allow for exploitation to take place, right? What we would consider to be unfair. I think I can't say much more than that. You know, in a sense for me, the objective was to say, look at this. So this comes about, I worked at the Yugoslav tribunal, and I was a kind of insider. I clerked for the president. I was sitting in a room a bit like this. We had the other law clerks in, and I was chairing, and we were in a case. What is slavery? Come back to me, 3 days, tell me. They come back. No idea. No idea, right? And so I didn't have, it was 10 years later that I had the opportunity. I'd finished with a project and I had an opportunity. I can remember thinking, you know, what am I going to do? And then I started reading around the history of the slave trade, and it's just a rich literature. People have done some very, very good work around it. And it just, you know, it brought me in. It's intellectually stimulating. And so that was the hook that got me interested in thinking about that, sitting in this room where people didn't know about this fundamental right? I was early days at the Yugoslav tribunal, and so every crime, it was like, what does this mean? Okay, let's work it out. And every one of them had a genealogy, except for slavery. And so that's what I embarked on, was trying to bring this identify and understand this genealogy. And so there's been benefits to it, you know, but and in a sense, I've been so focused on it that I haven't really started to think through these other elements, and I'm looking forward to tomorrow. And I've read, and one of the nice things about what I'm doing is that I get manuscripts sent to me, I get things sent to me, and oftentimes there are some interesting things, you know, I'm reading interesting things around it, and so it gives me the opportunity to start now thinking about where do we go from here, where do I go from here, and how do we think through these types of issues that I think are serious, and even, you know, to the sense that you have this eminent critique of what I'm doing, right? Do I accept that I am actually helping states in avoiding to address issues of true exploitation, of mass exploitation, because I'm creating this nuclear option in which they can just feel comfortable, and citizenry can feel comfortable in saying, oh, we got this person for slavery and that's not acceptable, when we accept that people are, in the context of where I come from, of where I'm living, of creating a society which is vulnerable, right, to know our contracts, this guy named Standing, I think is his Guy Standing, right? And he talks about a what is his term for the when someone is vulnerable, they are. It's not proletariat. It is something like this, right? Anyways, he's talking about a vulnerable people who are basically on minimum jobs, have no job security, and that they are vulnerable at any point, right? In the same way that if you think about debt bondage, right? Something happens in your life, right? Well, we're losing that safety net that protects us, right? And so in that perspective, I think that's probably where I'm heading, is to try to work on these more, what are the unintended consequences of what I'm up to.
Okay. There's a we have time, so John had his hand up before, and then
The precariat is the term. So those who are precarious in their labor, the precariat.
It's good that you can find it. Usually it takes me a lot longer.
Yeah, along the lines of some of the other comments, including your own, that when I saw the Bellagio statement, I sort of was trying to figure out, well, what would be, can I think of examples that would clearly be slavery as opposed to other things that would happen in a contract of employment. Sure. And I focused on words like significantly and coercion and exploitation, and I thought, well, if I knew what those words meant, I'd be much further along.
Yeah.
And then it reminds me of the response I have to the law of negligence as it currently is in Canada, where it's a sufficiently long statement that it seems like you're saying something, but in terms of predicting the cases, it's not much help at all.
Right.
And it all comes down to, well, what's the tribunal that's actually going to do this? I mean, society sort of decided that we're not going to try to define it with words. We're going to just have sensible people make the decisions.
Right. Yeah.
And I guess what do you foresee as being the tribunals who are going to make the decisions that are going to give the clarity we're looking for?
I mean, for me, that was the point, right? Is that we found ourselves in those kind of early cases of the Yugoslav Tribunal and of the European Court that they had no idea. Right? So at least what I was saying is, let's think of, you've got this wall that's got all these holes in it and you can enter through any part of it. Well, let's patch those holes up, let's give them a front door and they can walk through it, right? And at least then we'll get a sense that they're on the right, and then it's up to them to decide, right? So, I mean, I hesitate in the sense of trying to decide where those limits are. And again, I'm giving it to the courts to decide where, and in this case, I think the Tang case, I think in retrospect, I think 20 years from now, they'll go back and they'll say that wasn't slavery, right? It was something else. It was exploitive. It was debt bondage, but it wasn't slavery. But it was in the context where there was that Australia in this area around Melbourne had legalized brothels. But they wanted to establish some kind of limits to what was going on there, and so in that context, they were sending a message, in a sense. And so what may happen is that we may find in the early instances that there are decisions that go maybe beyond what 20 years from now we would come back to say that actually doesn't hold as slavery. That it's more serious than that. And in a sense, probably what we've seen in the Australian context is right around the time, well, between when the case was charged and when it got to the Supreme Court, they had introduced a lesser type of exploitation, a servitude. And so I think maybe there was also a realization there that cases, that something serious was going on, but it didn't meet that threshold of slavery. Now, let me just add one other thing, and I think it's a question that I often want to pose, and I haven't really had the chance, and that is the question about whether it debases historical slavery by talking about using the term slavery in a contemporary context. Right? I don't know the answer to that, but I think that there's a discussion to be had around it, and it's a discussion I really haven't had in any real a good hashing out of what the critique might be, and so I'm interested in that discussion. But for me, the question is, is that lived experience of someone that we would say who's completely controlled and they're being used, etc. Would that meet, is that for that person? It's a living hell in many ways, right? Is that acceptable to call that slavery, right? Or do we have to find a new term that establishes that, if we accept that it's not like it was when it was legal, when everybody accepted, right, that slavery was part of that, and anybody and everybody could, that the state the state also had a big part in enforcing it, and what that means in that context. So I think for me, I'm always very hesitant, and also, for me, it's quite easy to say this is way over the line and this is within. For me, the line is not, I think I'm very hesitant, having worked as a clerk and know what the judges are up to in the scenes, to give any kind of guidance, to say this is a case. Because it can be held, it can work against you, because at some point it may be that someone is is below that threshold, and yet that would be slavery. So I'm very, very conscious that I don't want to say this is slavery and this isn't. It's more about letting those that have authority decide, and then we go from there.
There's one last question. We don't want to exploit
just a short comment. I found what's very problematic about this new abolitionist wave is that, particularly in countries of the global north, they don't just try to, fight slavery in their own countries, but they do try to, put international pressure into other countries, particularly in the global south. So, for instance, what happened in 2000, the US made this act against victims of trafficking and violence, right? So what they do is they set these minimum standards. I don't know if they had to do with yours. I haven't read those. But they started pressuring countries, particularly in the global south, to change their policies, and they started to put a lot of money into NGOs that made that job, right? So, okay, I don't want to make a big story out of this, but if you look at Argentina, a lot of NGOs started to appear and started to fight against trafficking, etc. And what started after that, and the big criticism was that rescue industry started, right? So they started to get people who you may think or may not think that are enslaved, particularly sex workers, in the case of women trafficking for sexual exploitation. And they actually started this whole process of rescuing victims where they did not actually end up in a trial, but they just got processed as victims, so the numbers of rescued victims would raise. So my problem, with this, I don't know if a problem with, it's not your parameters, I haven't read them, but the idea of parameters that then are going to be used by judges is that most of the time nowadays with this neo-abolitionist wave is that judges are not really involved in the whole thing, in the big number of, and these minimal standards are actually being used, as Bourdieu would say, in a logic of hide by showing. So I show as if I'm fighting against slavery, and I'm actually hiding a lot of practices that actually reproduce and reinforce these exploitation practices. And particularly in the global south, that is terrible, because if you're talking about vulnerability, well, you're talking about populations where a lot of people, even in some parts, the majority of the population is in vulnerable situations. And who are you to say, not you, but these standards, how are you going to talk about vulnerability in a place like that? So is that person does it make that victim an empty subject who has nothing to say because it's vulnerable, so cannot decide anything, and they're going to come with this new legal arrangement that we have to change to get the founding, so we have to make these people, and it just reinforces exclusion more and more. But just, okay, so that's...
for me, so in the first instance is trying to understand this neo-abolitionist movement. And for me, it comes about primarily because the United States passes this trafficking in persons legislation that says if you don't meet these standards, we will not support you before the IMF and the World Bank, right? So if you look at who are the first to put in legislation, anti-trafficking legislation, it's all the states that seek and get money from the IMF that are within the U.S. orbit. In the same way as the states that aren't in any way associated with the United States are all at the bottom, and they don't care because it has nothing to do with them, right? And so this abolitionist movement comes about, and Bush it comes during the Bush era. And so there is this kind of right-wing agenda about saving women and about fallen women and all these things. So it's important to also understand what's transpiring around us, right? And then the other part is to ask the question from the victim's perspective, right? And so for me, that's also interesting, right? It's important in the sense that for me, it's not about these broad strokes, it's about the individual, right? And asking the question from the individual's perspective, right? What is going on with that person? And, is this intervention in this context of what you're saying, is it, to whom who benefits from that interaction, right? Is it the victim, or is it the NGO that gets the money? Is it the person that's employed to do this? Is it et cetera, et cetera, et cetera, right? And so from that perspective, right? So is this an elitist movement, right, which fails to address the true victims, right? Or does it in a piecemeal manner where we can all say, yes, there were these many cases and these many victims, et cetera, et cetera. It becomes a numbers game versus dealing with, as you said in Baudelaire, right? It fails to address the bigger issues that we've been discussing today, and that is that it fails to address issues of exploitation of a global economy in which a lot of people are, that there is clear inequalities. I've just finished teaching a module on the right to food, and the right to food is very interesting because for a very long time it was about a lack of food, right? And so 1 billion people who don't have enough to sustain themselves. But there was very little movement. In the last 20 years, 15, 20 years, right, you have now 1 billion people who are overfed, and as a result, they are dying from preventable disease. Now, food and food security issues are very much important because they are addressing people from the global north. They're addressing the elite in countries. And so all of a sudden, right to food is something that's become important, whereas before, no one worried about it. But it's interesting because you've got this dichotomy because when it was about people starving, we were willing to accept that 1 billion people could starve, right? But right to food has gained in prominence because it's about the other 1 billion who are overeating, who are killing themselves as a result of too much food rather than so much. So I think from that perspective, these are the dynamics that are continuously at play, and they're dynamics that I haven't really engaged with on paper as yet. And in many ways, it's a literature that I don't know all that well, but it's where I'm headed. It's where I'm headed, but I'm not there yet.
Great. I think that's a great, well, although cynical and sad place to end. No, in seriousness, I would like to thank Professor Allain for sharing his time and his thoughts with us, and for provoking what's a very rich discussion. And I love these occasions. It's not every speaker that can actually draw from such a wide audience across the university, and that's always a pleasure for us in the room. And I think some of you have already seen the Bellagio Harvard guidelines that François Crépeau put up onto the Nathanson site, so they're there if you're interested. I also brought Show and Tell, which is the book, The Legal Understanding of Slavery, which came out with Oxford in 2012. And also the recent publication that might be of interest to some people that's co-written with one of our York Schulich colleagues, Andrew Crane, is called Forced Labor's Business Modules and Supply Chains, and that came out November 2013 with the Joseph Rowntree Foundation, for those of you who are interested in that part. So I also just wanted to say that in addition to slavery, forced labor, right to food, there's a forthcoming piece on anarchy and international law. So we look forward to that. Thanks so much, Jean.
Thank you. Thank you. Thank you. Great. Thank you very much.